Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Morning, everyone. Our first case is North Carolina or North State Deli, LLC et al. Versus Cincinnati Insurance Company. And we will hear from the appellant.
May it please the court, my name is Stuart Painter, and I represent the appellant restaurants in this case. One of the owners is with me today in the gallery, Matt Kelly. I would like, if I may, to save 5 minutes for rebuttal, and I note that we are sharing 5 minutes of our time with the North Carolina Restaurant and Lodging Association. This case involves business interruption insurance purchased by my clients to cover lost income during periods where their normal business operations are interrupted. The policies are triggered by whenever there is a necessary suspension of operations caused by a direct, quote, loss to property at the premises. Loss is then further defined as accidental physical loss or accidental physical damage. And in this case, my clients were forced to suspend their business activities starting in March 2020 at the height of the COVID pandemic, when the governor issued an executive order limiting the operation of restaurants to only takeout and delivery. And that was followed by an order of abatement by the Secretary of Health that ordered the closure of their seating areas and bar areas. And as noted in the Amicus brief that was jointly filed by the North Carolina Restaurant and Lodging Association, the Restaurant Law Center, and the Angus Barn Restaurant, even before the COVID pandemic, closures that resulted or were triggered by viral outbreaks were of concern in the restaurant industry. And as a result, my clients, they specifically asked, the record shows that they specifically asked for coverage in case there was a closure triggered by a viral outbreak. And then the broker sold them the policies that are at issue in this case. And unlike most policies on the market, these policies, which were part of a package called the Cincy Pack for restaurants, they did not have a virus exclusion. And thus, at the time of purchase, my clients thought that they had coverage for closures that were triggered by viral outbreaks. And I submit that my clients were correct. These policies do provide coverage, and the Court of Appeals erred in holding that Cincinnati properly denied coverage. The crux of the dispute between the parties is whether my clients, the restaurant owners here, suffered a physical loss when the government orders that prohibited them from physically using their bar and seating areas and prohibited customers from physically occupying the premises. So the question is, was that a physical loss within the meaning of the policy?
So I wanted to ask a question about that. Suppose instead of it being COVID-19 that caused an emergency order that closed the businesses, suppose the government just passed a regulation and said, we're concerned about various harms that are coming from restaurants having too many people inside them. So we're only going to allow X number of people inside a restaurant, regardless of its size, and they'll have to space out the tables so people don't get in fights or trip and fall and get injured or whatever the reason. Would you say that that regulation would also trigger coverage under this provision?
So I'd like to answer that with 2 points. First, the policies also require that any physical loss result in a necessary suspension of operations. So in that case, I'm not sure that it would result in a necessary suspension of operations. So there may not be coverage for that reason. But let's assume that the restriction you're referring to is such that it results in a necessary suspension of operations. I think in that case, yes, if they were occupancy restrictions that resulted in a necessary suspension of operations, that would be covered. And when we get to the exclusions, I think you'll see that Cincinnati put exclusions in the policy to cover that very hypothetical that you gave.
Well, the reason I ask that is it undercuts your argument that what's in this policy is something your clients bargained for because they were concerned about a pandemic shutting down their business, because that's a far less likely event than just having the government come in and physically prevent you from using some portion of your business because they've created new regulations that limit your operations. You have a very broad understanding of physical loss that would cover that. And so I'm just trying to understand why you think there's anything about the policy that should make us think it was directed at something like the COVID pandemic.
Sure. So I think to answer your question about what my clients would have thought, what you say may be true in other industries. In the restaurant industry, though, that is something that is on everyone's mind, viral outbreaks. So I think in that sense, it's a little different than other industries. And I think that is why Cincinnati marketed these policies without a virus exclusion, because that would be something that restaurant owners specifically would pick up on.
I was just making the point that if they were so focused on that, you were bargaining for some language, you would have expected something that was directed at the virus and not at government regulation, because your theory really depends on us interpreting the words direct physical loss to mean loss of the physical use of the property. You say those are synonymous.
Yes, Your Honor. I think that when you refer to my clients bargaining with the insurance company, of course, that there is no bargaining process for these policies. They're sold as is. And my client expressed that concern that they wanted coverage. They had no ability to of course, bargain with the insurance company.
Well, but
which is
they do as a matter of how we treat contracts. And the way we get around that is you have a very favorable doctrine that says if there's an ambiguity, your clients are going to win. That's how we get around the reality of how hard it is to bargain with the insurance companies. But this is just we're interpreting a contract, and so the point would be you could tell as part of the contract negotiation, I'd like something different in this policy, and they could do that.
Well, I think the difference in the insurance context is that these are regulated forms, and so the way the industry works, the reality is, unless you're not even a multi-million-dollar business, but really almost a Fortune 500 company, you're not going to be able to get a bespoke policy from the insurance company. But I take your point that at the end of the day, this is a contract, and there is some level of negotiation or choice between the parties in entering into it. But in terms of the concern that
in looking at some of the other cases, I'm going to get in a second to what's happened in other states. But I mean, one thing I saw over and over in these other cases is there was something it's sometimes called critical event coverage. There was a separate necessary suspension coverage that seemed to be directed at the government shutting you down or those sorts of events that lead to the suspension. So that was sort of what I was getting at, is it seems like there are other lines of coverage maybe you could have bargained for that cover what you're saying this provision should cover. I'm
not sure there are other lines of coverage that they could have bargained for. I do know there are different policies that apply to venues, venues, but I don't think there's anything on the record that says one way or the other. But I think you're correct.
So let me ask you, because I think this is the big kind of elephant in the room, is I think your friends from the insurance companies are going to stand up and they're going to point to the fact that this exact same policy language appears in insurance policies all over the country and so many other state Supreme Courts. And these are not courts that you would sort of describe as, conservative pro-insurance company courts. We're talking, California and New York and Massachusetts and Maryland, and they've all looked at this and engaged in the exact textual analysis that you're asking us to engage in and said, that can't possibly be what it means. And as I kind of try to harmonize all their reasoning, what I see these other courts saying is that physical loss just isn't the same as physically being unable to use something. That physical loss, just the ordinary English words, mean it has to go somewhere. You have to be dispossessed of it. It's not enough to just say it's still here, but the government told me I can't use it. That's not a physical loss. That's the government telling you what you can and can't do with something you still have. So what's wrong with all those other courts' reasonings?
So I think a couple things. First of all, I think their linguistical reasoning is wrong. The term physical loss, as that term is ordinarily used in ordinary English, both physical and loss are extremely broad terms. Loss, in addition to being defined as the act of losing possession, is also defined as the failure to gain, win, obtain, or utilize. This is from Webster's dictionary. And so here, as a result of the government orders, they were physically unable to use these bar and seating areas. And so, and I think one of the distinctions, well, there are two real distinctions in this case. First of all, in this case, Cincinnati repeatedly admits in its brief that there is no necessity of physical harm or alteration, because it uses the term that you used, Justice, which was, I believe, a dispossession, a physical dispossession. So that's one of the definitions that Cincinnati gives of physical loss. But as we point out in our brief, if you look up the definition of the word dispossess in Webster's, there's only one definition, and it is to put out of possession or occupancy. And so Cincinnati's entire argument in this case, and I think which you articulated and which other courts have articulated, is that we are seeking compensation for occupancy restrictions. But that argument, that position of Cincinnati, I submit, cannot be reconciled with their own definition of physical loss as physical dispossession.
Well, that wasn't. So I remember reading, I think it was one of the Ninth Circuit cases, again, not a court that you would expect to be particularly favorable to insurance companies, but the reasoning they were articulating is that physical loss is in there because if you just said physical damage, you would be failing to include coverage that everyone wants to be in there. So it's possible, for example, if a restaurant owner opens the door to the restaurant in the morning and all the tables and chairs are gone, that there's been a theft, but it may be that later law enforcement recovers the stolen property and it's fine, and you put it back in. Well, there's no physical damage, but of course, during that time when the property had been stolen, you would expect to have insurance coverage if you can't operate the business. So you need a word to use to cover not just when it's damaged, but when you don't have it. And that's why the word loss appears. But that choosing loss and choosing loss of use are just so different in meaning that you can't conflate them. That seemed to be what these other courts were saying. So what's your response to that? Because I think that's what your friend is going to argue, is you're trying to add two more words to loss of use that just aren't in there in the policy.
Well, again, I think I'm relying on his own definition, which is to dispossess. And that is defined in the dictionary as put out of possession or occupancy. And so I think in the ordinary meaning of the term, any restaurant owner would think of this as a loss to property.
But forget about what he's arguing. Go with
Right.
my definition of what some other state Supreme Courts have said, which is if you open up your restaurant and all your tables and chairs and plates and forks and knives and the food, your employees are in the back because they're making takeout, it's all still there. You can't use it because Governor Cooper said you're not allowed to have in-room dining or in-restaurant dining right now. And that's just not a loss physically of anything. It's a loss of use of the things that are still physically there. That seems to me to be the reasoning these other courts have used. So I'm just looking for a compelling reason to say every single other state Supreme Court's got this wrong and we should say something different.
I agree that is what they're reasoning. And I think the compelling reason is, number one, as I said, that their own definition encompasses an occupancy restriction. And number two, In almost
When you say their definition, you mean in the policy, or
in
you're
their-
saying their legal argument?
their legal argument. Their brief on pages 22 to 25.
Well, I don't really care what they say the law
Right.
is. I'm trying to figure out what the law is here.
I understand, but I think it's a significant concession by my opponent. But in the other distinction between my case and all these other cases is that this case has unique language in the period of restoration. And I think if you look at the vast majority of those cases, when they come to this conclusion, when they narrow the ordinary meaning of the term loss, they are doing so by looking at the period of restoration often. Not in every single case, but in the vast majority of them. And that is because in the typical standard run-of-the-mill policy, the period of restoration is defined as the time it takes to repair, rebuild, or replace the premises. And just to back up, because this is a business interruption policy, there has to be some kind of temporal limitation on the time that, well, there doesn't have to be, but the insurance companies want there to be some kind of temporal limitation on the time they're going to pay you that lost income. And so that's what this period of restoration or period of limitation, as it's sometimes called, is for. And so in the ordinary case, and in Harry's Cadillac as well, it simply said repair, rebuild, or replace. In our case, however, and so the logical inference from that is that, okay, even if loss is a broad term in ordinary English, here it has to be the type of loss that can be repaired, rebuilt, or replaced. And that's not an illogical inference. That's not an illogical interpretation of those policies. But in this policy, we have a different period of restoration. We have a period of restoration that gives 3 alternative dates. It says, first is the standard one, repair, rebuild, or replace. Second is when the business is moved to a new permanent location, and that's not applicable here. And then there's a third alternative, which provides that the period of restoration ends, quote, 12 consecutive months after the date of direct loss. So we think in this case, you cannot infer from the period of restoration that the word loss should be cabined in a way, because this third alternative is a simple temporal limitation.
Is any of that inconsistent with viewing loss as requiring at least some kind of physical dispossession?
I don't think that period of restoration is inconsistent with it, but that it is inconsistent with an argument, the argument that Cincinnati and most insurers have made is inconsistent with an argument that the period of restoration should narrow the ordinary meaning of the term physical loss.
So I have a question about a word in the definition of loss, because it's not just physical loss. As I understand it, it has to be an accidental physical loss. What's accidental about being closed or being forced to suspend operations because of a government order?
So accidental in this context just means not, sort of intentional by the policyholder. No one, neither Cincinnati, no one has argued that coverage should be denied because it was not accidental. So I don't think that is an issue in this case. If this were direct physical loss, it would qualify as an accidental physical loss. And so the other reason, going back to your final reason, going back to your question, Justice Dietz, is that I think other courts have not looked carefully at the exclusions in these policies. And the exclusions in these policies, in my view, are really incompatible with this narrow cabin definition of physical loss. And if you look, there's a exclusion, for example, for basically a zoning exclusion. It actually says, it expressly excludes losses caused by ordinances that govern the, quote, use of any building. So it actually uses that term use. And basically, that is basically a zoning exclusion. And there's no reason for this zoning exclusion if loss of use, loss of physical occupancy is not covered under the policy. And in fact, that very same exclusion goes on to clarify that it applies, quote, even if the building or structure has not been damaged. So again, I think that supports our argument And then the second exclusion that, that supports our argument is that there's an exclusion for seizure or destruction of property by order of governmental authority. And so there, that exclusion really makes no sense if there's a requirement of physical harm, which is what the Court of Appeals said, because the reference to seizure or destruction makes clear that there can be some kind of non-destructive seizure, and you can still have physical loss. So I see I'm running out of time if I'm going to save enough for rebuttal, but I think there's one hypo that I think is helpful when you're thinking about this. What does it mean to an ordinary person? And that is, imagine the governor had come in, and instead of just issuing these orders, the governor or the Secretary of Health, they had, sent a state trooper or a government official down to physically rope off the bar and seating areas. I would submit that your average restaurant owner, a reasonable restaurant owner, and really any person would think that is a physical loss to premises when those areas have been cabined off and unavailable for their use. So unless the court has any other questions, I would like to turn it over to the North Carolina Restaurant and Lodging Association, and then I'll reserve the remaining time for rebuttal.
Thank you, counsel.
Thank you.
Good morning, Your Honors. I'm Guy Crabtree, and I'm here on behalf of the North Carolina Restaurant and Lodging Association. Our General Counsel, Executive Director are here this morning. I requested time to speak with you today on behalf of our thousands of members and employees throughout North Carolina to impress upon you the importance of this case to them, and ask that you overturn the Court of Appeals decision and acknowledge the coverage that the plaintiff and other North Carolina restaurant owners thought they were purchasing when they purchased insurance from Cincinnati. Cincinnati is a major player in the restaurant industry. When the plaintiff shopped for and purchased insurance from Cincinnati, they made reasonable decisions about the coverage they believed they were buying and paid their premiums, only to discover that Cincinnati refuses to compensate them for the significant losses that they suffered during the pandemic. While working on this case, I, like other attorneys here, saw Harry's Cadillac versus Motors Insurance cited by other courts to support the denial of coverage for various policy holders. And like the Court of Appeals in this case, some of those courts mentioned that decision in one or two sentences without delving into the salient details of Harry's Cadillac and how those details might impact the cases they were deciding. The defendants argues that Your Honor should affirm Harry's Cadillac, implying that to overturn the Court of Appeals here would overturn Harry's Cadillac. That's wrong. Your Honors can find for the plaintiffs here without disturbing or doing damage to Harry's Cadillac. How's that possible? It's possible by making a closer examination of Harry's Cadillac than the Court of Appeals did. Looking closely at Harry's Cadillac, you will find that the court there makes this important statement near the end of its decision. Quote, based on the language used in defendant insurance company's policy, we hold that the business interruption clause is not applicable to the facts of this case. So the Court of Appeals is telling us that Harry's Cadillac decision is limited to the policy language there and the facts of that case. The court also tells us early on in its opinion that its task is to determine the meaning of the policy language there, not here. Harry's Cadillac is 27 years old. It involves a different insurance company and a different insurance policy with different terms and conditions. For instance, the term loss is not defined in that policy. However, it is defined here. And as pointed out in numerous briefs and by the court below, its broad definition provides coverage to the plaintiffs. Also, and more importantly, the section setting out the period of restoration in the policy here is markedly different and more expansive than in Harry's Cadillac. That is significant in that the Harry's Cadillac court based its interpretation of that policy in relation to those facts almost entirely on the definition of the period of restoration. The period of restoration here adds two additional clauses that support an expanded definition of the term loss to provide coverage in this case. So, Your Honors, you can and should interpret this insurance policy with the factual situation here to provide the coverage to the plaintiff and others in the restaurant industry that they reasonably thought they were purchasing when they paid their premiums to Cincinnati. Thank you.
Thank you, counsel. Is the state prepared at this time?
Mr. Chief Justice, Associate Justices, may it please the court. My name is Kaylee Chozek, and I'm here with the North Carolina Department of Justice as amicus in support of plaintiff appellants in today's case. The state agrees with the plaintiff appellant's argument with respect to why the language direct physical loss is at a minimum ambiguous in today's case. In light of this ambiguity, the Court of Appeals erred in agreeing with the insurance companies in allowing it to deny coverage to the plaintiff appellants. I'd like to take a few minutes to focus on why this court should continue to follow its long-standing precedent in interpreting ambiguous insurance contracts in favor of the policyholders. For starters, this policy protects North Carolina consumers, like the small business owners here, who didn't have any say in drafting the policies. North Carolina consumers, when finding these policies, don't have any bargaining power in making these decisions. It's the insurance companies that are drafting these policies and choosing all of the language that goes into the policies. And so in order to protect these consumers from the inequities of insurance contract drafting, it's important that this court continue to follow its rule in interpreting ambiguous language in favor of the policyholders. And we can see that at issue here. Cincinnati was the company that completely drafted this policy, and even though one of the plaintiff owners intended to have this type of loss relating to viruses covered under his policy, because he knew that was something common in the restaurant industry, Cincinnati now states that that is not covered under this insurance policy. And yet that was something that he reasonably understood was included. So if this court agrees with Cincinnati that the policy is clear and unambiguous and that direct physical loss does not include loss related to virus as experienced here, then that will leave these small business owners with virtually no other option. And that's exactly why this court needs to follow the rule in interpreting ambiguity in favor of the policy holders. Similarly, it's up to the contract drafters, the insurance companies, to make sure that the language is clear and unambiguous. And that can also be seen here as Cincinnati had an opportunity to include a virus exclusion, which it includes in many of its other contracts and is typical in the contract industry now. But Cincinnati chose not to include that here. And if it had done so, we wouldn't be here today. Perhaps in part, Cincinnati didn't include it because it was aware that the owners wanted virus coverage under their policy and reasonably believed that it was. But because Cincinnati wasn't clear in drafting its policy and the small business owners had no say in their policies, then the court should find the ambiguity in favor of the policyholders and hold that direct physical loss includes loss related to business interruption with respect to viruses. In conclusion, the state of North Carolina wishes to emphasize that this court continue to follow its longstanding precedent in interpreting insurance contracts that are ambiguous in favor of the policyholders. In doing so, this court can continue to protect the state's consumers, like these small business owners, from the inequities of insurance contract drafting. Therefore, the state respectfully requests that this court reverse the Court of Appeals and reinstate the trial court's holding in favor of the policyholders. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court. My name is Daniel Litchfield. I'm one of the attorneys representing defendant appellees, the Cincinnati Insurance Company and the Cincinnati Casualty Company. I'm joined at the table by Mr. Gary Parsons of Brooks, Pierce, McClendon, Humphrey, and Leonard, and also present in the courtroom is Mr. Thomas Hogan, who's the Chief Legal Officer of Cincinnati. And the insurance policy here is a commercial property insurance policy. I think I state the obvious, but it's critical that I state that because that sets the context in which we're dealing. A commercial property insurance policy. An adjunct to the coverage in that commercial property insurance policy is what we call business income coverage. It's not called business interruption, it's actually formally called business income coverage. And that's an adjunct to the commercial property coverage. The commercial property coverage is intended to protect people from accidental direct physical loss or accidental direct physical damage to their property. Hence the emphasis on those words. And it's important to back up a little bit and put that in context because our policy says in all events there has to be accidental direct physical loss or accidental direct physical damage to property. And then you do a separate analysis as to what we call covered cause of loss, which is everything except what is excluded. That's not a workaround that causes one to avoid the necessity of accidental direct physical loss or accidental direct physical damage in all events for any of these coverages. That's for the main coverage. If somebody needs to have their tables and chairs repaired or replaced, that's what we cover because it was damaged. If somebody needs to have their income protected while that repairing and replacing is ongoing, that's what we cover. But at the root of all of that is the requirement of direct physical loss or direct physical damage to the property. The argument here is that government orders caused a choice to drop out of business for a period of time. Even though the government said you can continue to run your kitchen, you can continue to do carry out and delivery. That was a choice. The fact of the matter is that's a loss of use at most due to government regulation.
Counselor,
Yes.
I would like to direct your attention because I'm struggling with one point, and it has to do with the virus exclusion provision. If we agree with you that the plain language of the policy only allows coverage for the direct physical loss, which is what you're arguing now, at least that's my understanding, why is there a virus exclusion provision at all? How does that work? I mean, why would you even have that in a policy at all?
It's not in our policy.
No, I understand that, but I know it is part
In other
of what,
people's policies.
right.
Agreed.
And so help me understand that interaction.
Well, certainly consistent with the record, what I can observe is that Cincinnati has chosen not to have a virus exclusion in their policy. Part of the reason for that choice is because they only cover accidental direct physical loss or accidental direct physical damage. There would be no reason to have a virus exclusion on these sorts of facts in that kind of a circumstance, unless, of course, you wanted to add some extra coverage for somebody. That was done here with what's called an eating establishment food contamination business interruption endorsement. That's at page 524 in the record. That endorsement doesn't apply here, and they've never asserted that it does. It's for foodborne illness. I think that would be something that a restaurant would be concerned about, that you're making your customers' tummies sick and you want to have coverage for that kind of a circumstance. That's in here, but a broad virus exclusion, we've chosen not to do it. And I think the company has stated in other contexts that it never believed that it was necessary. And I would suggest that the incredible wave of precedent of all the state Supreme Courts that have addressed this issue, all the numbered courts of appeals that have addressed this issue, all those many U.S. district courts, all those many state appellate, intermediate appellate courts, that wave of precedent, I think, supports Cincinnati's faith that it has a clear and unambiguous provision in its policy that does not require that it load on a virus exclusion as an additional factor.
So I wanted to ask you about that because, I mean, I agree with you. Your client sort of has the wind at its back. Every court that seems to be examining this policy language agrees with your interpretation, says this doesn't trigger coverage. But as you heard from a friend in the Solicitor General's office, we have a doctrine here in North Carolina that says if there's any ambiguity, we have to construe that ambiguity in favor of the policyholder. And an ambiguity in a contract is where there's more than one reasonable interpretation. And so the question I'd like you to answer is, we just heard your friend for the policyholders make a series of arguments that did not sound to me to be unreasonable. And if they're not, if those are reasonable arguments for a reasonable alternative interpretation of the contract, doesn't your client lose, even though you might have the better argument? Because there's another reasonable argument for what this language means. So why is their position so unreasonable that there's just no ambiguity?
It's so unreasonable because it does not show a reasonable alternative for the following reasons. First of all, I think collectively the arguments that we're seeing, they ignore the fact that context matters. And that is important according to the precedents in the state when evaluating whether contractual language is in fact ambiguous. You need to look at the context. What's the war on context here? First, there's the deconstruction argument. That's actually a term that linguists use, deconstruction. And that's where you try to make a series of words that everybody thinks they mean one thing, means something entirely different. It's a fun parlor game, but I submit it's not what the courts in this country or historically in this state have ever done. The deconstruction argument is one where you cherry pick definitions from multiple dictionaries of various of the key terms. And then you put those back, you reassemble the pieces to mean something that's out of the context of the original pieces. It is a war on context. One example of that would be the definition of loss. They're fans of the Merriam-Webster dictionary. I think my friends cited that multiple times in their briefs as well as their amici. The definition of loss, the first definition in Merriam-Webster is destruction, ruin, not a word. Because that wasn't one of the definitions that they cherry-picked to put into their reassembled definition of accidental direct physical loss or accidental direct physical damage. Right. So the war on context also comes in the or argument that we see. I am pleasantly surprised that after all, more than 40 years of practicing, I now argue the meaning of the word or. And I think the problem with that argument is that they say that in all events it's either or but never both. Somewhere along the way I joined the bar of a U.S. District Court, and I forget which one it is, and I apologize to them for not remembering. But they had a local rule in their rules that said that when you're addressing those on the bench, you should address them as judge or your honor. Never occurred to me even once that a judge is never a your honor and that a your honor is never a judge. Or I think has to be read in context, just like all these other words.
So I do think there's a connection.
I apologize.
No worries. I do think there's a connection between the question of the fact that many other policies, I think I saw something like 82% of all policies that have this accidental direct physical loss or accidental direct physical damage language do have virus or contamination exclusions. And the notion that it's reasonable to assume that the language of this particular policy, which doesn't have that exclusion, those two are somewhat related, and that it was reasonable for these restaurant owners to assume that if their policy, as an all-risk policy, if it didn't have that virus exclusion the way so many other policies do, that they had coverage here.
I'd like to address that in at least two parts, and more may occur to me as I get rolling. First and foremost, Allstate versus Shelby, this court held that the terms and conditions of another policy are an inappropriate basis to determine the meaning of the policy in front of the court. That's just not the contract that we're talking about. That's something that I think ought to resonate in this situation. Secondly, it's important to back up and delve a little bit into the concept of an all-risk policy. That's a label. It's not our label. The words all risk don't appear in this policy anywhere. I've done the Control-F keyword search. I looked for it. It's just not there. It's a label that people apply to this contract in argument and sometimes in the cases. And I'm not castigating people for using that label. I'm just saying that when we're at the level of analyzing the meaning of specific words and where the stakes are, whether there's an ambiguity, whether there's an alternative reasonable interpretation of those words, then I think it's important to look at the actual words of the policy and not to operate at the level of labels, which aren't always necessarily in conjunction with the policy. The policy here, as I stated earlier, makes it clear that there can never be any coverage of any sort, whether coverage to repair, rebuild, or replace a table, or coverage for business income while that's going on. There's no coverage unless you have accidental direct physical loss or accidental direct physical damage. And that's the important point that I need to keep returning to, because that really is a very important part of answering your question, Justice Steets, which is, isn't this a reasonable alternative interpretation? No, it is not. And here's the best reason why I conclude that it is not. And I want to preface what I'm about to say by being very careful to tell all of you that I'm not suggesting for a minute that this court should follow the decisions of any other court in any other state, much less the federal courts. That's not what my following comments are about. I've been at this over 40 years, and since May of 2020, with the social life decision from the Southern District of New York, which famously held that COVID is about damaging lungs, not printing presses, in the context of property insurance policy. Since then, there have been all of these hundreds and hundreds of cases that have been cited to you that overwhelmingly hold in favor of my client's position here. And I'm not saying that you need to follow those or that you need to go with the wave. You'll decide that, and I understand that. But my point is, in these 40 years that I've been privileged to be an attorney, I've never seen anything like this. I started out in antitrust, then I did some CERCLA cleanup work, and then I found myself doing some IP stuff, and then some insurance litigation. And one thing after another, I've never seen the courts of our land, state Supreme Court, state appellate courts, federal courts of appeal, federal U.S. district courts, be so much in agreement on something. The rapport is astounding to me, just from an academic point of view. And I keep asking myself, why is that rapport there? And again, my observation isn't that you should slavishly follow the decisions of other states or have a tote board and just follow the ones that have the most. That's not it at all. Why is that there? Why did something so extraordinary happen in the last 4 years? And I think I know the answer. I think the answer is because overwhelmingly, all of these judges from all of these different jurisdictions, all over our great land, looked at this and determined that this language is clear and unambiguous. And they said so. But that speaks more to the clarity and lack of ambiguity of this language than anything else.
Does how does the period of restoration provision factor into your argument? Do we even need to look at it, in your view?
I think we win without your looking at it. But if you look at it, I would love to see you do that, because it's no different than the one in Harry's, and it's no different for any meaningful purpose than the ones in all these other precedents. Why do I say that? They focus on a distinction without a difference. My friends say, look, usually there's two subsections to when a period of restoration ends, either when the property should be repaired, rebuilt, or replaced, or alternatively, when they resume operations at a new location, which I think everybody would agree is awfully darn physical in terms of the requirement of some physicality in order for our coverage to apply. All right. We added this third alternative, it's the earlier of these three alternatives, which is 12 months. Why is that? If you look at the declarations page of our policy, we don't have a limit on business income coverage. There is no dollar amount stated there. It says 12 months ALS. What does that mean? 12 months, all loss sustained. Okay, so if somebody is entitled to business income coverage, and many are, and many have been, and many will be in the future, just not on these facts. If somebody is entitled to that coverage and they're getting 12 months all loss sustained, clearly when you get down to the period of restoration provision, you have to account for the fact that the coverage is not limited by a dollar spent. It could be $10, it could be 10 million. It's how many months did it take for them to work on restoring their property. And how are they restoring their property? They're rebuilding, repairing, and replacing. And you can see that in the provisions in the policy that define our duties to pay loss. What do we pay? We pay for rebuilding, repairing, and replacing. Essentially, that's it. And so this distinction is a distinction without a difference.
So in other words, if I understand you correctly, you're saying not only are the differences between your period of restoration provision and those in Harry's Cadillac, not only do they not support, well, first of all, they're consistent with your definition of physical loss, and they don't support any other definition.
They do not. They do not. How could one possibly determine whether the 12-month alternative is the earlier of the three without first analyzing when they should be physically repaired, physically replaced, or physically rebuilt as one of the alternatives? Because if that's quicker, you don't worry about 12 months. And how could you determine whether the 12-month provision would be the earlier of the three without analyzing the time it took them to reopen in a new location? A clearly physical act. Something physical about that is entirely consistent with our argument. You couldn't do that without first analyzing the facts of that reopening, which are all about physical events. The 12 months is just a hard stop. Why? Because our limit is for 12 months. It's consistent with the coverage that we extended and nothing more. If that's the earliest, then that's how much coverage they get. But they're working all along at repairing, rebuilding, or replacing. They just couldn't get it done in 12 months. That then resonates to accidental physical loss and accidental physical damage. Because we know from the Woodall case and Woods and other precedents, Akari, that have been cited to this court, that it's important to look at the entire policy as a whole. And that's why we look at the period of restoration language, is you have to harmonize it with our core insuring provision of accidental physical loss or accidental physical damage. And that harmonization occurs at the level of how do you repair, rebuild, or replace without something physical having happened. Repair, rebuild, or replace doesn't apply if the government cuts down the number of people you can have in your dining room. And our friend admitted earlier that they think that would be covered. Well, the fire department does that every day. I walk into a restaurant, it says occupancy limit, and there's a number of people there. Boy, that's a far cry from, I think, any reasonable assessment of what accidental physical loss or accidental physical damage ought to mean. That's why there's no
Would you concede that your policy could be clearer?
No. No, Your Honor, and for several reasons. First of all, I'm not trying to be a stick in the mud, and I'm certainly not in the throes of zealous advocacy. I really don't think it could be clearer. And the main reason is...
Would we be here if it were clearer?
I don't know. I don't know. That's the kind of metaphysical question that I would love to be able to answer. I suspect...
Well, here's what I'm getting at. If we think it could be clearer, does that mean it's ambiguous?
No, and here's why. We've seen a little bit of this with my friend's arguments even today. Every word in the English language, with very few exceptions, has at least two, if not multiple, definitions. We see that with loss. And then you multiply that by the number of dictionaries, which themselves will have different definitions, some overlapping and some not, for the very same word. At the risk of getting knowing nods, I would suggest that everything I say, in that environment without context, everything I say here today could be considered pure gibberish. Now, I hope I don't see any knowing nods, but the point is, context matters in the English language. It matters the world. Otherwise, how do we know? If I get a piece of paper in the mail that says court hearing this date, be there. You know, if I go look at the dictionary, I could get very confused. Well, court, is this a basketball court? Tennis court? What's that all about? Hearing. Oh, is that the auditory physical sense of hearing sounds that come to my ears through the air? Or do I know what court hearing means? In context, I know very well what it means. Examples abound. I would challenge you to take just about any clause or phrase you see in the newspaper or whatever you choose to read for information and go to the dictionary. I do this from time to time because this fascinates me. Look up all the meanings for each of those words in a phrase and then ask yourself, how does that phrase make any sense absent context?
But certainly you could have, I take your point, but certainly you could have said in the policy, physical loss does not include loss of use.
We could have said that.
Would that have been clearer?
I don't think so, because where does that then lead? What we've seen from my friends is that we then go to the dictionary for whatever else we say. And now we're looking at all the definitions in 5 dictionaries for the word use.
But the policy does have definitions of many terms, and it doesn't define this term.
Right. It does not over-define, and I think there's good reason for that. First of all, given my comment about the English language, I think if an insurance company were to define every word in its policy, then it would be incumbent on the company to define every word in the definitions of the words. We heard that already. I make an argument where I use the word dispossession, and it comes back to me what the dictionary says dispossession means. Although in the context of what I think I'm saying in my brief, it's an argument characterizing a line of cases and arguing why that line of cases should not trouble us here today. Insurance departments are, in my experience, extremely oriented toward being sure that policies are clear, clean, and easy to read. If you were to have a policy that's bigger than the Manhattan phone book, because you define every word in the policy, and then you define every word defining every word in the policy, and then you define every word defining every word, and so on and so forth, there's no end to it. And that's why in the English language we stress context so much. That's why linguists will tell you context matters. That's why this court's precedents, like Akari and Woods and Woodell, that's why they stress context. And I don't think there's any reason to fear that, and we certainly don't. And I think the best evidence of the power of context, again, is those 20 state Supreme Court decisions plus the District of Columbia and all the 11 numbered circuits and on and on and on. And again, I stress, I'm not arguing you need to follow those decisions. You'll do what the state of North Carolina needs you to do, and I appreciate that, and I want to be on record about that. But my point is, how do you get that rapport amongst all those hundreds and hundreds and hundreds of cases within 4 years? I submit it's because this language is so clear and unambiguous that there's no reason for a court to go another way. And the very few situations that they've pointed out to try to say, hey, look, here's a court that strayed one way or the other, we see quotations to Brown's Gym in Pennsylvania, but that's overruled by the Hungarian court in their Supreme Court. And we see citations to the intermediate appellate court decision in Hungarian, but that's overruled by the Supreme Court in a recent decision. We see citation to the legal seafoods case from the District of Massachusetts, but that's overruled by the First Circuit Court of Appeals, again going our way on that very same proposition. That's overruled by Verveen from the Massachusetts Supreme Judicial Court, which is addressing the same policy language, the same or similar facts, and comes out finding that there is no coverage. That happened with the Studio 417 case, which we see cited against us in the briefs that are before you today. But the judge who decided that later went the other direction in the K.C. Hops case, which was a companion case, decided the same day, and incorporated by reference the Studio 417 decision. He later went another way when doing some jury instructions. And then the Court of Appeals, the Eighth Circuit, applying Missouri law, went the other way in multiple, 3 other Eighth Circuit Court of Appeals cases. So there's reasons why the cases that my friends are relying on to argue against us are just no longer good law. They aren't. Back to the idea of sort of the war on context. I think it's important in that context to look at what are referred to as the exclusions in our policy. A lot of the cases being cited in this regard are not property insurance cases. Property insurance policies work a different way from your standard general liability policy or a homeowner's policy. We're used to a circumstance from that milieu where you read the grant of coverage and then the exclusions are exclusions from coverage where it's otherwise covered. The difference here is that the basic requirement of accidental physical loss or accidental physical damage permeates everything first. You don't need to talk about a single exclusion, ever, if there's no accidental physical loss or accidental physical damage. For this coverage, the business income coverage, the policy says that the suspension in operations, which is required for the business income coverage to apply, has to be caused by accidental direct physical loss or accidental direct physical damage. If you don't have that, there's nothing else to discuss. And that's part of the reason why we tried to keep our brief, as clean as we could. Staying away from long discussions about exclusions and the like, because we believe so strongly that that is the end of the analysis, as it has been in so many other cases. I would also want to comment briefly that a number of arguments are getting made about things that people thought, things people wanted, things that Cincinnati thought, and things Cincinnati wanted to do, for which there is absolutely no record support. When I hear people talk about what Cincinnati intended to do to corner the restaurant market so we won't have a virus exclusion, not a scintilla of evidence in the record of any such thing. That's just pure speculation and argument. We're all prone to argument, and it's our job, but that's the kind of proposition about which I would hope there would be some evidence before going off on that tangent. And there simply isn't any. To recap, once permitted context is applied, and that's the context that's required by the precedents of this court, this language is clear and unambiguous. In proper context, plainly, there needs to be some physicality to the direct loss or the direct damage. It's direct physical loss. Physical modifies loss. If it's not physical, then that's not the kind of loss we cover. Same on the damage side. Plainly, this policy, as written, does not cover mere loss of use or economic loss that's untethered to those concepts of physicality. Again, it's a commercial property insurance policy. It's not a profits coverage. It's not a government regulatory costs coverage. It's a commercial property policy. Costs of government compliance with regulation, we've given you the slippery slope. We've seen it here today. If occupancy limits on a dining room from the fire department, no, you can't have 300 people in this 50 by 40 room. If that is covered, and we heard that that's the aspiration of my friends, It's getting so far afield that context has become a victim.
Well, counsel, let me ask a question based on the hypothetical presented by your friend on the other side. He mentioned that perhaps there's some sort of incident that occurs and the government essentially cordons off an area or the entirety of a business. Has that business been physically dispossessed of use of that property?
Perhaps for a short time in that hypothetical, and here's where I think the court might want to direct its gaze. There is a coverage that was the source of briefing and disagreement in the lower courts, and I mean down at the trial court, that we afford for business income, and we call it civil authority coverage. And the key to the civil authority coverage is the paradigmatic civil authority coverage situation is we're coming back from lunch and the police officer says, you're not allowed to go into your building. The building next door is on fire. We're afraid it's going to jump across the alley and nobody's being allowed in there. Okay? You've got direct physical loss or damage to that other building. That's one of the triggers for this coverage. Absolutely has to be accidental direct physical loss or accidental direct physical damage to other property, not the policyholder's property, to other property for that coverage to apply. And then law enforcement putting a rope around your business and saying you can't get into it, I think that sounds like a prohibition of access to me, which is the other important element of that coverage. Now, the reason that coverage doesn't apply here is, first and most importantly, there's no direct physical loss and no direct physical damage to some neighboring property. There's not even an effort to say that, other than to say, well, it's everywhere. COVID's everywhere. Okay, that begs a lot of questions, and that's as far as this record goes, is that argument. No facts, no evidence. Moreover, we didn't have a single order from the government that said that your access to your property is prohibited. Prohibit's a pretty big word, and it's not an equivalency kind of question-begging word. I mean, if a judge tells me that I'm prohibited from doing something, Mr. Litchfield, you're prohibited from filing another brief, I don't file a 1.5-page document and say, well, prohibited, it's just partial. It's a partial thing. No, prohibited means prohibited. In this context, there's no coverage unless the policyholder is prohibited all access to their property, and that wasn't done by the governor's orders. Starting with order number 117 and working up to 131, it's not there. As a matter of fact, as counsel conceded, those orders expressly stated that you are not allowed to serve people in your dining room or in your bar, but you can use your kitchen all you want. You can sell carry out and you can sell delivery. Right? That's what the orders did not prohibit access. All of these policyholders could go on their premises at any time, as early as they wanted, stay as late as they wanted, and do anything they wanted there, except they couldn't serve people in their dining room for a period of time, and they couldn't serve people in their bar for a period of time. That was the government's regulation. Right? So we're not dealing with the civil authority coverage, but I would submit the roped off example lends itself the most to that kind of a hypothetical, but I need to change the hypothetical to find you some coverage. But it's there, and it's applied all the time and paid all the time. It's a common situation. We call it communicated fires. Building next door is on fire, it's ablaze. No, you don't let people into the building in case it hops the alley and consumes the second building. That's not taking good care of the public. So I think that's the answer to the hypothetical, but a roped off place without more is at most a temporary, I'll say, dispossession of that area. And that's not even enough based upon the so-called dispossession line of cases that are cited in my friend's briefs. Those are permanent, total dispossession situations. Those are situations where in those precedents, the property is rendered practically useless for anything. And that's not at all what we had here. They returned to the place, and all the record indicates, and all indications are, that they went back to business as usual after a period of time. No new tables, no new bar stools, no new walls, no property claims for direct physical loss or damage to any of their property. They just would like some payments under the business income coverage, which again is only available if there's accidental direct physical loss or accidental direct physical damage. If there are no other questions from the court, I just ask the court to please affirm the Court of Appeals and recognize the clear and unambiguous language that is afoot here, and very much appreciate the opportunity and privilege to address this court. Thank you very much.
Thank you, counsel. Rebuttal.
May it please the court, I'd like to briefly respond to some of the points raised by Cincinnati. First of all, I think his answer to my hypothetical demonstrates why any ordinary person would be completely befuddled by Cincinnati's interpretation of the word physical loss. When if the governor were to send someone in to rope off your seating areas and to rope off your bar areas, any normal person is going to think that is a physical loss to property. And I think what Cincinnati is trying to do here is to read into the phrase physical loss, which it says is a physical dispossession, read in total or complete, a complete or permanent. They're trying to read other terms into it. But a loss, as we all know, can be total or a loss can be partial. You can be completely dispossessed of your property, or you can be partially dispossessed of your property. And the court should not go out of its way to read those terms into the policy for Cincinnati when Cincinnati was the one who drafted this policy, and it could have said total physical loss. It could have said complete physical loss.
But I know you're on a rebuttal, I apologize, but just assume hypothetical, there is an execution on a judgment. Sheriff goes out to your client's property and puts his hand on your client's vehicle and says, I'm seizing this vehicle, the tow truck will be here in an hour to satisfy this judgment. Is that a physical loss in the period between the sheriff being there and the tow truck coming?
I think it's a physical loss if you are legally prohibited from using that vehicle. And I don't know that you would be in that hypothetical, but certainly if you are prohibited from using or occupying your property, that is a physical loss. And keep in mind, again, there are other exclusions in the policy that cover these situations. And I don't think we heard any answer from Cincinnati of why physical law, they keep saying that these are occupancy restrictions and we are seeking compensation for loss of use. And that is correct, but there is a exclusion that excludes, a zoning exclusion, and this is, I believe, Doc X 213. And we didn't hear any explanation of why they have to explicitly refer to, quote, use of property in the exclusion if it would not otherwise be covered. All we heard was that, well, property insurance policies are read differently than homeowners policies. Well, my clients, they don't know that. They didn't know that. Now, at the end of the day, the term physical loss was chosen by Cincinnati. It is a broad term. It is a vague term. And they accuse us of cherry picking definitions. And they seem to think that there's something wrong with consulting dictionaries, even though this court has said in the Allstate versus Chatterton case that when a term is undefined, it's appropriate to go look at dictionary definitions. And when there are multiple definitions, if multiple of those definitions make sense within the context of the policy, then the insured is entitled to pick which one they rely on. There's nothing improper about that. And you heard him say, well, we were cherry picking our definition of loss because there's one of the definitions of loss refers to an inability to utilize. And he said, well, the first definition is destruction or ruin. Why didn't we pick that one? Well, the reason is that destruction or ruin doesn't make sense in the policy as drafted, because the policy as drafted, everyone concedes, covers theft. And so we didn't pick destruction or ruin because that doesn't make sense within the policies as drafted. And interestingly, historically, destruction was the alternative. It was destruction or physical damage. And that's in the amicus brief by the United Policyholders. But it was Cincinnati that expanded it to physical loss. And I see my time for rebuttal is out. So I thank your honors, and I would urge you reverse.
Thank you, counsel. Mr. Clerk.